Imagine this scenario for a second. Just picture it. You're a manager, right?
Yeah.
And you have this employee who has been, well, they've been struggling for a while.
Right. A classic situation.
Yeah.
We've all been there.
Exactly. And you sat down with this person, face to face, multiple times, and you're telling them, hey, you really need to improve your performance.
But nothing really changes.
Nothing changes. So flash forward, say, 3 or 4 months, things haven't gotten any better, and you finally have to make the tough call.
The termination meeting.
Yeah. You bring them in, you sit them down, and to your absolute shock, this employee looks you dead in the eye and claims they were never, ever told what they needed to change.
Oh, wow. Yeah, that's the moment your stomach just completely drops.
It really is. Suddenly the panic sets in. Everyone is scrambling. You're like digging through old emails, frantically scrolling through chat histories on Slack, trying to piece together, calendar invites for meetings you had.
Just desperately trying to reconstruct the actual truth.
Right. And it is a genuinely terrifying position for any manager to be in. But welcome to our deep dive where we're going to help you make sure that never happens.
That's because reality is that specific nightmare happens every single day in businesses across the world.
It really does. So our mission today is to unpack this really comprehensive guide from Stellapop. We're looking at their research on how everyday, seemingly mundane employee issues secretly morph into these massive business risks.
And more importantly, how you can actually stop that mutation right in its tracks.
Exactly. So jumping right into it, what's the core idea here?
Well, the central thesis of the Stellapop material provides a really, really crucial framing for this entire discussion. They state very clearly, this is a quote, "Most employee problems do not begin as legal problems. They become legal problems when memory becomes the record."
Memory becoming the record. I mean, that sounds almost philosophical, right?
It does, but the application is incredibly practical.
Yeah, and I want to set the tone right out of the gate here for you listening. We are not talking about, creating some covert secret HR file on your team.
No, definitely not.
This isn't some masterclass in scheming to fire someone or, building a trap. We are just talking about basic, fair, and transparent management.
Exactly. When this process is done right, yes, it absolutely protects the company. But primarily, it supports you as a manager, and it gives your employees a genuinely fair chance to actually understand their shortcomings and improve.
Right. Because the ultimate goal of documentation isn't just to generate, more defensive paperwork to stuff into some dusty filing cabinet.
No, the goal is to create a reliable, objective record. And the problem is that memory, as cognitive science continually tells us, is just notoriously unreliable.
Oh, completely. It's so flawed.
It really is. It's highly malleable, especially when you introduce stress or conflict into the mix. So you, as the manager, you remember warning the employee several times with, grave seriousness.
But they remember it totally differently, right?
Yes. They remember one casual passing chat by the coffee machine where you just offered, a piece of friendly advice. And the dangerous part is that you both genuinely believe you're telling the truth.
Okay, let's unpack this. If memory is basically the enemy of a reliable record, how do we actually write things down without letting our own biases or, our emotions take the wheel?
That's the challenge, right?
It is. I was thinking about this, and to me, good documentation should function sort of like an instant replay in sports.
Ooh, I like that analogy.
Yeah, think about it. When you watch an instant replay, the camera just shows exactly where the player's foot stepped out of bounds. It just shows the physical reality of the moment.
Right, the camera doesn't care about the context of the game.
Exactly. It doesn't show whether the referee thinks the player is a jerk or if the player was feeling unmotivated that day. It just shows the bare facts. But I have to push back a little here.
Go for it.
Realistically, when you are in the middle of a heated conflict with an employee, your blood pressure is up. Isn't it just basic human nature for a frustrated manager to jot down, this employee is being completely unreasonable and has a terrible attitude?
Oh, absolutely.
So how are you supposed to turn off your human reaction?
Well, what's fascinating here is how the source material explicitly addresses that exact tension. It draws a hard, definitive line between a conclusion, which is essentially a feeling or a judgment, and a fact.
Okay, so conclusion versus fact.
Yes. Human nature absolutely relies on cognitive shortcuts. We want to label things so we can process them quickly. We just want to say someone is difficult and move on.
Because it's easier.
Way easier. But in documentation, writing what you feel or the conclusion you've jumped to is the most dangerous trap you can fall into.
Yeah.
You cannot write what you assume. You can only write what you observe.
Okay, so let's dig into how that actually translates to the page. Because, recognizing a bad attitude is easy.
Right.
But documenting it without actually using the label, that seems way harder.
It requires a bit of a translation, really, a translation from judgment to behavior. Let's take your example of a bad attitude. Writing, Jordan has a bad attitude, is an opinion. It's a subjective conclusion.
Yeah, it doesn't really say what happened.
Exactly. If an outside party reads that, they have no idea what Jordan actually did. Instead, the factual record, your instant replay, would look like this. During the June 12 team meeting, Jordan interrupted two coworkers, raised their voice after being asked to wait, and left the room before the discussion ended.
Oh, wow. Yeah, that is a completely different ballgame.
It is, isn't it?
You aren't accusing Jordan of a character flaw at all. You're just providing the timestamps and the physical actions. You're letting the behavior speak for itself.
Precisely. Let's look at another one. Something managers deal with constantly. Someone writes, Taylor is unreliable.
Oh, I see that one all the time.
Right. But again, that is a vague label. It's a character judgment. The factual record translates that too. Taylor arrived after the scheduled 9 a.m. start time on June 3, June 7, and June 11 without notifying the supervisor.
And the beauty of that instant replay camera is that it just sees Taylor walking in past 9 a.m. on 3 specific dates. It doesn't see the word unreliable.
Right.
It doesn't try to guess why Taylor was late. It just records the event.
Exactly. The key takeaway for you listening as a manager is that you must ruthlessly eliminate vague emotional labels from your vocabulary when you're documenting.
So words like what?
Words like lazy, toxic, unstable, aggressive, insubordinate, or difficult. Those have absolutely no place in your official record unless the document explicitly details the observable physical behavior that led to that word.
That makes a lot of sense.
And furthermore, the guide is adamant that you must never, ever speculate about an employee's health, their internal intentions, or, their emotional state.
Because you aren't a doctor and you can't read minds.
Exactly. If someone is crying, you don't write, they were having a mental breakdown. You write, the employee began crying. Facts are specific. They could be reviewed objectively by a third party, like an HR director, a mediator, or a lawyer, who was never in the room when the event actually happened.
So we know that the gold standard is writing down the facts, stripping out the feelings, and providing that instant replay. But, that brings up a massive operational hurdle. Time. We are all incredibly busy. Managers are stretched so thin. If a perfect record is required, how do you document this stuff without spending 4 hours playing amateur lawyer every Friday afternoon?
Trying to draft legally binding affidavits.
Yeah, exactly. Nobody has time for that.
Well, the relief here is that you don't need to write like an attorney to protect yourself and your company. In fact, trying to write in legalese usually backfires.
It just makes the document super confusing.
Yeah, exactly.
And the source makes a really compelling point about timing in this regard. It insists that promptness actually overrides perfection.
100%.
Like a quickly scribbled sticky note or a brief email to yourself written on the same afternoon the event occurred, that is vastly superior to a beautifully formatted 5-page memo that you try to, reconstruct from memory 3 months later.
It's all about contemporaneous notes.
That's right. And frankly, think about the optics here. If a manager suddenly produces a giant, pristine pile of complaints right before they decide to fire someone, it looks incredibly suspicious.
It does.
Even if every single word is true, it looks like a fabricated hit job.
It looks entirely retaliatory. In legal or HR proceedings, a sudden avalanche of documentation is just a massive red flag. A consistent series of timely, immediate notes is always more useful and carries so much more credibility.
Yeah, that makes sense.
But going back to your point about not having the time to play lawyer, the solution isn't drafting essays. The solution is adopting a consistent structure. The Stelopop guide actually breaks this down into 7 specific questions that act as a framework.
7 questions, okay.
If every record answers these 7 questions, you are covered.
I looked at this framework, and what struck me is that it acts almost like a managerial Mad Libs.
That's a good way to put it.
It kind of forces you to remove your bias. It asks for the basics, but then it forces you to look at the rule book. Let's actually walk through these 7 questions using a hypothetical scenario just so we can see the mechanism in action.
Okay, let's do it.
Let's say we have an employee, we'll call him Alex, who keeps turning in work late, and it's holding up the whole team. Where do we start with the 7 questions?
So the first 3 questions establish the baseline reality. Question 1, what happened? Question 2, when and where did it happen? And question 3, who observed it?
Okay, so in our scenario, you wouldn't write Alex is always holding us up.
No, definitely not.
You would write Alex submitted the Q3 financial analysis on Thursday at 4 p.m. The deadline was Wednesday at 9 a.m. This was observed by myself and the project lead, Sarah.
Perfect.
Okay.
Clean, factual, objective.
But here's where it gets really interesting. Question 4 asks, what expectation, policy, or job requirement applies to the situation? Because you can't just write down turning things in late is unacceptable.
Right, you can't just state a grievance.
You actually have to explain the underlying business impact.
And this is perhaps the most critical step, and honestly, it is the one managers miss the most. If you don't connect the behavior to a specific business expectation, the conflict just looks like a personality clash.
Just a strict manager getting annoyed at a relaxed employee.
Exactly. You have to anchor the conduct to something the employee could reasonably understand, like a written policy, a bullet point in their job description, a stated performance goal, or even a previous coaching conversation.
It's like building a firewall between personal annoyance and actual professional standards. So in our scenario with Alex, instead of just saying, the report was late and I'm super frustrated, you write the business impact. You write, the Q3 financial analysis was due by Wednesday at 9 a.m., so the executive team could review it before Thursday's board meeting. Because it was submitted Thursday afternoon, the board meeting had to proceed without the financial data.
Right. And do you see how that completely changes the narrative?
It really does. It removes the manager's ego from the equation entirely.
Yes. The problem isn't that Alex offended the manager by missing a deadline. The problem is that the executive team couldn't do their job. It shifts the focus purely from personality to performance.
And that makes the actual conversation with the employee so much easier, too. Which brings us to question 5. What explanation did the employee provide?
Yes.
I think this is vital because it implies you are actually required to have a conversation and listen to them. This isn't just some one-sided burn book you're keeping in a locked drawer. You have to record their side of the story.
Legally and ethically, that is crucial. If Alex says, well, I didn't have access to the accounting software for 2 days because IT locked my account, and you failed to document that,
then your record is just a lie.
It's incomplete and it's fundamentally unfair. You have to include their explanation, even if you completely disagree with it.
Okay, then we round it out with the final 2. Question 6, what coaching, warning, or action was given? And question 7, what must happen next and by when?
Right.
So you document that you gave a verbal warning and that the next report is due next Wednesday by 5 p.m., no exceptions.
Exactly. It creates a complete closed loop. You've established the facts, the business rule, the employee's perspective, the consequence, and the path forward.
Okay, so if we are documenting perfectly using these 7 questions, it brings up kind of a terrifying thought.
Uh-oh, what's that?
Does this perfect documentation make a manager bulletproof? Like, if I fill out the Mad Libs correctly, am I completely safe from business risk?
Not at all.
Not at all. Because how you treat this specific employee compared to how you treat other employees in similar situations is where things can get incredibly dangerous. Consistency is the next major trap.
Okay, let me play devil's advocate for a second.
Go ahead.
Does this mean we have to act like robots handing out standard issue demerits? Like if one person is 5 minutes late because their car broke down on the highway and another is 5 minutes late because they just overslept, do they have to get the exact same written warning just to prove we are being consistent?
Well, if we connect this to the bigger picture, the law does not require you to be a robot.
Okay, good.
Outcomes do not have to be strictly identical in every single case because context absolutely matters.
Right.
An employee's history with the company, the severity of the specific incident, their tenure, their role, and the overall business impact of their behavior. All of that might differ. However, the golden rule here is that the company must be able to clearly and objectively explain the difference in treatment. So, if you give the person with the broken down car a pass because, say, they have a flawless 5-year record, but you write up the person who overslept because they've been late 4 times this month, that is fine.
That's totally fine.
But you need to have a legitimate, documented business reason for that discrepancy.
Exactly. Because if you lack that documented business reason, it opens the door wide to accusations of discrimination or retaliation. And the source material highlights some incredibly specific legal landmines that managers routinely step on here.
Yeah, you have to be extraordinarily careful if you are disciplining an employee who has recently engaged in protected activities.
Be very careful.
Right, because the timing of discipline can look retaliatory even if it actually isn't. If an employee has recently raised a discrimination complaint or, requested a workplace accommodation for a disability or reported a safety concern or even participated as a witness in an internal HR investigation.
They are essentially operating under a legal shield.
Exactly.
Federal and state laws are highly protective of those activities.
Yeah.
If someone reports a safety violation on Tuesday and you suddenly decide to fire them on Thursday for being 5 minutes late, something you usually completely ignore for other employees.
Boy.
Yeah. The courts will almost certainly view that as illegal retaliation.
And there was one specific protection in the text that I think catches a lot of managers completely off guard.
The NLRA.
Yes. You have to be very careful if employees have recently discussed workplace conditions or pay with their coworkers. The source explicitly mentions that this is protected by the National Labor Relations Act, the NLRA, even if your workplace doesn't have a union.
Even without a union. That is a very widespread misconception.
People always think it's just for unions.
Countless managers assume the NLRA only applies to unionized environments. It does not.
Mm-hmm.
The law protects what is called protected concerted activity. When employees act together to address pay, benefits, or working conditions, they are legally protected.
So if an employee is leading a charge asking for better wages on a Slack channel, and suddenly they are disciplined for a minor dress code violation that literally no one else gets written up for.
That company is walking right into an NLRA violation.
So the crucial rule here is that having perfect documentation does not magically make a retaliatory decision lawful.
No, it doesn't.
You can't just fill out the 7 questions perfectly as a smokescreen to fire someone who just asked for a raise. The documentation must always reflect a legitimate, supported, and consistent business reason.
The paperwork never shields you if the underlying motive is illegal or inconsistent. It simply provides the factual basis for a legitimate, fair decision.
Okay, so let's say you have navigated these legal landmines. You're documenting fairly, objectively, and consistently. In the event of a lawsuit, every single piece of paper, every email becomes potential evidence.
Everything.
So where is a manager actually supposed to keep all this highly sensitive proof? Do I just keep a folder on my desktop named Do Not Open?
Definitely not. Storage is actually a highly regulated, high-risk area. The source is very clear that different types of records have to be treated fundamentally differently.
How so?
Well, standard performance reviews, your coaching notes answering those 7 questions, disciplinary records, and attendance info, those generally belong in the official personnel file managed by HR.
Okay, that makes sense.
But anything related to medical information, disability accommodation records, or sensitive investigation materials absolutely requires separate, confidential storage. You cannot mix an employee's medical history in with their quarterly performance review.
And I want to get a little passionate about this next point because I see managers do this all the time. The source explicitly warns against the creation of an official file.
Oh, yes. Shadow HR.
Yes, shadow HR managers keeping notes on their personal cell phones or in those private little notebooks they carry around, or just scatter across random text message threads that the actual human resources department can't see or access.
Shadow HR is a nightmare for a company's legal counsel.
It's so bad.
Because if HR doesn't know the information exists, they can't help you evaluate the risk or guide your management strategy. Furthermore, if there is a lawsuit, those personal devices, those notebooks, and those text threads can suddenly become discoverable evidence.
Which means a lawyer's going through them.
Exactly. You do not want a court subpoenaing your personal iPhone just because you use the Notes app to track an employee's performance.
That sounds like a disaster. And the retention rules are strict, too. The EEOC requires private employers to keep personnel records for at least 1 year.
Right.
And Department of Labor rules regarding wage records can require even longer retention. State laws add even more layers. The overarching point is that record keeping is formal, regulated work, not some casual side hobby.
This raises an important question, though. If we are building these meticulous, formal files, does the employee actually know about them?
Right. Are we just sitting in the dark building a secret case against them?
The StellaPop guide is crystal clear on this, and it goes back to our earlier point about fair management. Documentation is meant to support communication. It does not replace it.
Okay, support, not replace.
The absolute worst-case scenario for a company is an employee reaching the end of the disciplinary process, being handed a termination notice, and asking in genuine shocked confusion, why was I never told this was a problem?
The no surprises rule.
Exactly.
If they are surprised at the end, you have fundamentally failed as a manager.
Completely. Managers should always be discussing the concern with the employee directly, in real time. You explain the expected change, you document their response, and you clearly confirm what may happen if the issue continues.
And the source provides some really actionable advice on how to formalize that communication without making it super adversarial. You might ask the employee to sign the document you've created.
Yes,
But, and this is a critical distinction, the form needs to make it abundantly clear that their signature just proves they received the document. It does not mean they agree with every single word you wrote. It is just a receipt of communication.
and to maintain that fairness, you should always allow the employee to provide a written response and attach that response to the official record.
That's a great policy.
It guarantees their voice is permanently part of the history. To make this entire process a habit, the guide suggests keeping it as simple as possible.
Right, because if it's complicated, managers won't do it.
Exactly. A straightforward, one-page form covering those 7 questions that managers can fill out easily and consistently is infinitely better than some complicated, overly bureaucratic software system that managers actively avoid using until a situation has already exploded.
So what does this all mean? Let's bring this all together for you listening. If we synthesize the core message of this entire deep dive into the Stella Pop Guide, it's that good documentation is ultimately a leadership tool.
It really is.
Yes, it protects the company legally, but its primary function is better management. It takes those vague, simmering, emotional frustrations you feel as a manager and forces you to translate them into clear, objective conversations.
And it acts as a firewall.
Right, actively separating personality conflicts from actual business impact and performance issues. And most importantly, it gives your employees specific expectations and a genuinely fair, understandable chance to step up and improve.
It's entirely true. I know it might feel like tedious bureaucratic paperwork today when you were already busy with 100 other tasks.
Yeah, it's a lot.
But early, consistent, factual documentation is the only mechanism that prevents difficult workplace situations from ending with nothing but competing unreliable memories. It saves time in the long run, it protects working relationships, and it stops avoidable misunderstandings from mutating into wildly expensive legal battles.
Well said. I want to leave you with a provocative thought to chew on, something that builds on everything we've talked about today regarding memory versus the record.
Yeah, I'm intrigued.
We live in a heavily remote work era now, right? Almost all of our communication happens via Slack, Microsoft Teams, or email. We are constantly passively generating a massive, chaotic digital footprint every second of the workday.
That's true.
Does this reality make the memory versus record problem easier to solve because technically everything is already typed out and searchable? Or does it actually create a much greater risk?
Oh, that's interesting.
Because managers might mistakenly rely on those scattered, out-of-context chat logs to prove their point, assuming the system is doing the work for them, instead of taking the time to sit down, remove their emotions, and write a clear, objective, and unified document that answers those 7 vital questions.
It's a fascinating tension for modern businesses.
Yeah.
Just because mountains of data exist in a chat server doesn't mean a coherent, fair, or legal record actually exists.
Exactly. The instant replay camera is rolling 247 in our chats, but if you don't know where to look, or you only clip the isolated parts you want to see to support your own bias, you're not documenting fairly, you're just cherry-picking evidence.
And that's a dangerous game.
It really is. Thank you so much for joining us on this deep dive. We hope you take these insights and that 7-question framework into your next management challenge. Until next time, keep the instant replay focused entirely on the facts.